Good morning. Welcome to the Long Live Third Parties podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Fulani v. Smith, 640 SO2D1188, Florida District Court of Appeals, 1st District, 1994. Friends, we're going to talk about third-party candidate Lenora Fulani again. So let's get fascinated by third-party ballot access. Yes, this case involved Lenora Fulani and her New Alliance Party. This case shall inspire us. This case involves a coalition as the Taxpayers Party, the U.S. Taxpayers Party, which is now the Constitution Party, joined Lenora Fulani's New Alliance Party. So let's read from the record. It says, quote, Appellant Lenora Fulani, a member of the New Alliance Party, sought to be that party's candidate for president on the write-in ballot in November 1992 election. Appellant Marina Muniz sought to be the party's vice presidential candidate. Appellant John Frankenville was candidate for presidential elector pledged to New Alliance candidates Fulani and Muniz. Appellants Howard Phillips and A.W. Knight Jr. are candidates for president and vice president respectively as members of the U.S. Taxpayers Party of Florida, end quote. And it continues to say, the U.S. Taxpayers Party missed the deadline, but what happened to the New Alliance Party? Let's find out. It says, quote, Neither the New Alliance Party candidates nor the taxpayer candidates satisfy the filing requirements of the above statute, although it is noted that the New Alliance Party candidates missed the filing deadline only by approximately 2 hours. End quote. 2 hours. That is missing it by a hair. So do you think the state should have granted the New Alliance Party an opportunity because they just missed it by a hair? Do you think if one of the two parties missed it by a hair, they would have given them access on the ballot? Maybe your third-party candidate says that's fair. What do you think about that? How close should it be if they're going to do it? What if it was 5 minutes? What if it was an hour? That sounds awfully close. They could have made an exception here, but they stuck to the letter of the law. And in this case, our friends of the New Alliance Party invoked the 1st and 14th Amendments, which we mention happens in these ballot access trials again and again. Not every ballot access trial involves that, but a great majority of them do. So what happened in the end here? Did the court grant our friends some leniency, some grace? Let's read. It says, quote, Accordingly, we find, as did the court below, that appellants have failed to demonstrate how the statute adversely affects a federal or Florida constitutional right. After carefully reviewing the record and the briefs of the parties, we find no basis for reversal. Accordingly, the order under review is affirmed. End quote. So, friends, the New Alliance Party and Lenora Fulani did not win this one, but we got to give them a hand because they fought again. We didn't see Fulani once, but now we see her twice fighting this good fight. So may this empower and impact third parties to get ballot access. Long live third parties. Goodbye.